cause of negligence in a court of law. Okay, that is the formula. Major premise, minor premise, and conclusion. Major premise, minor premise, and conclusion. You will eat and sleep deductive reasoning and its three components, major premise, minor premise, and conclusion, for the rest of your legal career. That's it. That's how it goes. So let's analyze that. Let's look at the rule of law of negligence. Well, what's the rule of law of negligence? In fact, the rule of law of negligence has four elements, four slices of the pie. Remember that pie that we were slicing up? Think of the elements of any rule of law. Think of the elements of a civil rule of law, of a criminal statute, of an administrative regulation, of a city ordinance. Think of it as little pieces, slices of a pie. So negligence, being the pie that we're dealing with now, has four slices. A legal duty. There has to be a breach of that legal duty. There has to be legal and actual and legal causation, and there has to be damages. You cannot have 3 out of 4 elements or slices of the pie. You cannot have 2 out of 4 elements. If you don't have all 4 slices of the pie of negligence, you might as well pack up and go home. Adios, baby, bye-bye. That cause of action is not going to fly. It doesn't matter what the rule of law is. Each element that makes up that rule of law has to be satisfied. So the question becomes, what has to happen before I can, or the lawyer can file an actionable cause of action in court for an auto accident? There has to be a cause of action of negligence. There has to be a legal duty. There has to be a breach of that legal duty. There has to be actual and legal causation, and there has to be damages. The legal duty. Did the defendant conduct him or herself in such a way as to create an unreasonable risk of harm to the plaintiff or anyone else on the freeway or the highway or the street? Secondary is the second element. Was there a breach of the legal duty? Did the defendant act in such a manner to cause the injuries that the plaintiff is complaining of? Actual and legal causation. Did the defendant, but for this defendant and his or her conduct, the plaintiff would not have been injured in the manner in which the plaintiff was injured? Or that analysis of actual causation is but for or substantial factor. Was the defendant a substantial factor in creating the conduct and conditions that led to the plaintiff's injuries? Fourth element or fourth slice of the pie that has to be analyzed is whether or not the plaintiff sustained damages. We're not talking about damages. Oh, I've got an owie on my elbow. No. We are talking about actionable damages for which there is what's called a raise, a RES, a raise that results from a judgment in a court of law by suing that defendant and getting money damages. That is what that lawyer is going to be concerned about, is how much does this case generate in terms of a judgment that comes out of this to help heal the client, to get paid in the process for the work that the law firm and all the law firm and support staff does to bring this case to fruition, to an amicable settlement or a judgment in a court of law. Now, in analyzing each slice of that pie, my friend has to kind of quickly look at the facts, because either the facts are relevant or they're irrelevant. Okay. Was there a legal duty that the defendant owed? Well, that's pretty much a given. That we can a priori assume that if they were on a public street and they were driving vehicles on a public street, that the defendant had a legal duty on that public street to not create an unreasonable risk of harm to the plaintiff or anyone else that was on a public street. Okay, so that's pretty much a given that there was a legal duty that was owed. The plaintiff had a legal duty as well as the defendant who had a legal duty. Was there a breach of the legal duty by the defendant? That is where my friend's expertise, my friend's research is going to play a very important part. Did the plaintiff have any medical history? Was the plaintiff healthy? Was there any question about their condition? Was there some question about the defendant's condition? Are there any medical reports that show that he might have been under the influence of something, or he was impaired by medication that he was taking? And if so, my friend can then tell the attorney what effect that medication would have at any given time on that defendant to have acted in such a way that might be negligent and therefore was the cause of the plaintiff's injuries. But in doing that, she's going to have to appreciate how the breach of a legal duty is important, and in analyzing the negligence cause of action just that way. She's not going to spend time on whether or not there was a legal duty, because she knows there was a legal duty. They were on a public street together. They were in vehicles, and they drove those vehicles on a public street. So there was a legal duty to not create an unreasonable risk of harm to anyone, and least of all the plaintiff in this case. The question, therefore, becomes, was there a breach of the legal duty? Okay? And what was the defendant doing? What was the plaintiff doing at the point of impact? Those are very relevant questions that my friend is going to have to review in the case itself. And also, was there actual and legal causation? But was there something the plaintiff did? Was the plaintiff comparatively negligent? We don't know. Those are facts that will be pointed up in the case, and my friend will talk with the attorney about. But you see how she will be framing her questions and mentally where her head will be on the negligence cause of action, because that is the chief cause of action anytime you have an auto accident and you're suing for personal injury and property damage. You always go to that place called negligence, okay? And, of course, if it's just a simple straight negligence, then that's where you go, and there might be an issue of intentional infliction of emotional distress or negligent infliction of emotional distress. Those are other causes of action which she'll analyze by looking at the complaint to see what the plaintiff's attorney sued for in a court of law. She's going to have to analyze each one of those causes of action, and she'll do it the same way. The major premise, the minor premise, and the conclusion. Every single time, it does not matter what rule of law it is treated by the same formula. A major premise, which is the cause of action and its elements. The minor premise, which are the facts of the client's case. And if you fit each fact into each element of that cause of action or negligence, guess what? The conclusion has to be you've got an actionable cause of action in a court of law. And whether or not there were damages that flowed from the defendant's conduct and the injuries to the plaintiff. Can those damages be tied directly to that event? If those damages can be tied directly to that event, guess what? You now have damages. You have satisfied the fourth element of the cause of action of negligence. Duty, breach of duty, actual and legal causation, and damages. Now, and of course, the damage issue, at the time that you're reviewing the case, that's the first place you're going to want to go, because that's where the lawyer's interest is going to be, on whether or not there is damages, and if so, what is the full extent, so that based upon what my friend has to say about the prognosis, about how severe or if she has some knowledge about where these cases, how these cases might have been decided in similar cases, she can share that when she gets as well versed and expert in the area of a legal nurse as I certainly hope one day that she will be. Let's take for a minute the crime of common law burglary. And why am I talking about common law when I know that there's such thing as statutory burglary that has replaced common law burglary? Well, the conjunctive and the disjunctive or are very, very critical in properly reading and analyzing rules of law. Okay, the crime of common law burglary, and you can write this down if you want, or you can get the book. It's right in the book. In analyzing common law burglary, first off, anytime you see the word shall or must, it is mandatory language. If you see the defendant may move for a change of venue at or before the preliminary hearing, that may means it's permissive. He can if he wants it. If he doesn't want, he doesn't have to. But if it says the defendant must or the defendant shall move for a change of venue at or before the preliminary hearing, that is exactly what the rule of law says. And everything after the word, the verb, the auxiliary verb, shall or must, has to be followed to the letter of the law that is written. You must accept the literal interpretation of everything that follows after the word shall and must. It is mandatory language. So when you see that, highlight it with your marker so that when you come back and you review that, you'll go, oh, that's mandatory. Shall is there or must is there. So that's mandatory language, and that's how I have to read that rule of law. If the word is may, then it's permissive, which means it's discretionary. So you're going to highlight that too so that you will apply the correct interpretation to the rule of law. Now, common law burglary is, and I'll take the time for you to write this down, but I'll recite the rules, the elements. Remember the slices of the pie. There's 7 of them in common law burglary. The trespassory, breaking and entering, breaking and entering, breaking and entering, breaking and entering, the dwelling of another in the nighttime with an intent to commit a felony or stealth therein. There has to be, what has to happen before this rule of law will follow? That's the question. That's the question of negligence. What do I have to bring a negligence cause of action into court? Duty, breach, cause, and damages. What do I have to prosecute a defendant for the common law of burglary, of common law burglary? You got to have a trespass, a break-in, entering the dwelling of another in the nighttime with an intent to commit a felony or stealth therein. You've got to have a trespass. That is the first element of common law burglary. You must, mandatory language, you must have a trespass. Somebody trespassed on the property of the victim. Okay, because now that we're dealing with a criminal case, we don't have a plaintiff in this case. The plaintiff is the people of the state of California. The victim is the person whose house was burglarized, and the defendant, of course, is the perpetrator of the crime, the accused of the crime. So we've got to have a trespass, which means, and what is a trespass? You see how you got to slice up the pie and analyze each slice to really understand what each element means. You've got to have a trespass. The district attorney at 6 p.m. Would you be trespassing? Of course you would not, because there was consent for you to enter the premises between the hours of 7:30 and 10 p.m. If you came onto the premises at 3 o'clock in the morning, that would be a trespass because your consent is not continuing. Your consent has been cut off at 10 o'clock p.m. It's fear or apprehension. Assault is fear or apprehension of an imminent, harmful or offensive touching. Fear or apprehension. So if a little old lady is crossing the street and this guy sees the little old lady's handkerchief fall on the sidewalk, and when they get across the street, the young guy taps the lady on the shoulder and says, "Ma'am, you dropped your handkerchief, here you are." Was there an assault? Was there fear or apprehension? Well, if you're doing a nice deed for someone, more likely than not, most people don't fear, especially in broad daylight. If the guy looked kind of nice, if he looked like Bubba, it might be another issue. But if the guy looks fairly clean cut, the little old lady probably was not in fear or apprehension. So is the first element of assault satisfied? No, it is not. If the first element cannot be satisfied, there is no point in going to the other three. It's over with. You can't show that. You can't prove that there was a fear or apprehension of an imminent, something about to go down right now, that assault that's coming at me, and I am in fear or apprehension. It is coming down right now. And it looks as though it could be harmful or offensive. If you touch someone and they don't know you, that's probably an offensive touching. I mean, a lot of people are just touchy that way. Fear or apprehension of an imminent, harmful, or offensive. So it could be harmful or it could be offensive. And the third element of assault is still satisfied. Of a harmful or offensive touching. Did the young man touch the old lady? Yes, he did. He touched her on the shoulder to tell her, here is your handkerchief, you dropped it, and I'm returning it to you. So was there a touching? Yes, there was. Was it harmful or offensive? Probably not. Okay. Was it an imminent, harmful or offensive touching? No. Was it their fear or apprehension? No. So the conclusion has to be, you don't have an assault. Okay? You've got your major premise, which is the rules of assault. You analyze the facts of what happened between the man and the old lady. None of the facts fit into the slices of the pie of assault. Therefore, the conclusion has got to be there was no assault. Now, change the facts a bit. What if the young guy knew the old lady had a special kind of neurosis, and if someone touched her, she just went ape? Now you have someone that has certain knowledge that their touching this old lady would cause her apprehension. And anytime you have that condition that's operating, you've got yourself an assault. My friend will analyze each one of the rules of law that she engages, whether it's in the code, whether it's an administrative rule, whether or not it's a local rule of court, that she has to go through each one of those rules to see what is the court saying that I have to satisfy in order to be a witness in this case and to testify as a witness. The local rules will tell you that. The California Business and Professions Code will tell you that under the rubric of consultant and the sub-rubric of nurse consultant. That's where you can look for that. You can go online at Westlaw or Lexis and do a sub-search for consultants, and then do a sub-search of the sub-search of legal nurse. And we'll look for what elements or slices of the pie do I have to satisfy of this rule of law that governs me testifying. What elements, what slices of that pie do I have to satisfy to conclude that I can testify? So my friend is going to know those rules when she comes into that lawyer's office for an interview. She's going to know those rules that govern her code, because she can anticipate there is an expectancy interest by that lawyer that she knows this. Okay? Now, I happened to pull out, because I was quite interested, to know exactly what are the types of issues that a nurse consultant, a legal nurse consultant, would be addressing when performing the job of a legal nurse consultant. And a couple of things are evaluating causation and evaluating damages. That's the third and fourth element of negligence. Remember the four elements of negligence? Duty, breach, causation, and damage. Well, if the nurse consultant is going to analyze and evaluate causation and damages, She has the understanding of the 4 elements of negligence down cold. She would have to even go there. Okay? That's how you analyze and think like a lawyer. They will love you for it. They know you're there. They know you've arrived at that understanding of how to process rules of law. Not case law, but rules of law, codes, administrative regulations. Anything that's a rule of law that governs the fight, that governs the rights and obligations of the party, are your rules of law. And that is the absolute first place you will start in your analysis of any case. You've got to know what are the rules and regulations and the rights and obligations of the parties toward one another. What can our client expect in the way of her or his or her rights being protected? What are the obligations, if any, of our client? You need to know the rights and obligations of each party. And those are defined in the California codes. There is the aviation code. There's a business and professions code. There's a civil code, the code of civil procedure. There is the education code. There's a fish and game code. There's a health and safety code. There's a penal code. There's a tax code, a vehicle code, welfare and institution code. All of these codes are there to govern the fight involving human events of parties. And practically every human event that has ever occurred is there in our California code. Now, there might be a couple of things, because when in vitro fertilization was a hot button issue and those types of cases were never decided in California courts, there was no law in the code to govern that. So we had to take rules and law and case law that occurred in other jurisdictions to bring into California to interpret those cases until there were enough judges that had a consensus of opinion as to how those cases should flow and fall out. So we are fairly able to get the rules that govern the fight on just about every conceivable human event that has happened in California or that will happen. Okay, I hope this helps in terms of understanding that lawyers really do think a certain way, and you have got to appreciate how they think in order to engage them. And once you do that, then they know you know that you're now on their team. You're now that paralegal they're looking for. You're that great paralegal that they can leave that work with and know that it's going to be handled, know that it's going to be interpreted and interpreted correctly, because you understand the formula. It's in the book, okay? Hope you get it's on Amazon.